Literally counting heads.
The House Criminal Justice Committee will come to order. Would the clerk please take attendance?
Chair Hope.
Here.
Representatives Andrews.
Here.
Carter.
Present.
Breen. Young.
Here. Here.
Arbit.
Here.
Devendorf.
Here.
Cerniglu.
Here.
Filler.
Yes.
Mueller.
Here.
Bazat. Harris. Bagol.
Here.
Madam Chair, you have 10 members present. You do have a quorum.
Thank you. Representative Arbit moves to adopt the minutes from the September 26th meeting. Without objection, the minutes are adopted. And we will now hear testimony on House Bill 4850. We have testifying in support of her bill, Representative Glanville. Go ahead and get started when you're ready.
Thank you, Madam Chair, members of the committee. The bill before you today, HB 4850, would amend PA 236 of 1961, the Revised Judicature Act, to provide that service members of the U.S. Armed Forces may request an exemption from jury duty service while they are on active duty by providing a copy of their orders, and that they must be granted an exemption upon making a request. So the Act currently only allows individuals who are more than 70 years of age, nursing mothers, or those assigned to a witness protection program to claim exemptions from jury service. I think it's clear that our active duty military members are dedicated to civil service. They're not just trying to get out of it, right? And DoD policy actually encourages full civic participation, including jury duty, as long as it doesn't compromise readiness. However, fulfilling this particular civic duty can at times create a hardship for our military members. Without this exemption, military service members are required to request time off duty, pay and coordinate their flight home, and be available for the selection process, where they may be told they are not selected. And this is exactly what happened to one of my constituents, Army Major Meredith Stegerda. She's currently stationed in Fort Leavenworth. Her father, a veteran himself, contacted my office to share her story, and I believe you have a letter from him. After having deferred once, she received a second summons. She could have put in for a hardship determination, but the exemption in this case is not automatic. She would have had to wait for determination, and if it were denied, would potentially be required under penalty of law to leave her post at Fort Leavenworth, pay for last-minute flights home, and participate in the jury selection process. To be honest, I thought there was a misunderstanding when I heard about this. I mean, surely active duty service members must be exempt from local jury duty. Upon further investigation, we discovered that while they are exempt from federal jury duty, that exemption does not exist at the state level in Michigan. And I was not alone in my misunderstanding. As I made the rounds to collect co-sponsorships for this bill, I was met with the same disbelief from colleagues of all political stripes and was able to gather a wide contingency of support from both sides of the aisle. So in closing, allowing our military members to request jury duty exemption is a simple way for us to show our appreciation for the civic duty they perform every single day in the line of duty. I urge a yes vote, and I'm happy to answer any questions.
Thank you, Representative. Any questions? Representative Andrews.
Thank you, Representative. Was just curious if there was a reason that spouses weren't included, and if not, if you're open to spouses also being included.
Yeah, that's a great question. I know my recent bill did include spouses, kind of a similar idea here, I think. So I think we could certainly talk to stakeholders and see if there are any reservations or reasons why they shouldn't be included. So yeah, we can take that up. Happy to have a look at that.
Awesome. Thank you.
Mm-hmm. Thank you.
Thank you, Representative.
Thank you.
That was perfect testimony, no questions. Yes. We'll now turn to testimony on House Bills 4948 and 4960. Representatives Snyder and Grant. Please go ahead when you're ready.
Good morning. Thank you, Chair Hope and committee, for the opportunity to speak on the legislation that Representative Snyder and I are presenting today, House Bill 4948 and 4960. These bills aim to build on the clean slate reforms that happened in 2020. These reforms expanded expungement eligibility to over 1 million Michiganders. They streamlined the application process and are currently allowing thousands to clear up old criminal convictions that are eligible. The petition-based expungement guidelines changed in 2021 and were put into effect in April. In one day, over 250,000 Michiganders saw their eligible convictions become expunged. These individuals now have a clean slate and have an opportunity to secure new opportunities in life. Michigan is a leader in the nation on expungement policy, and I believe that we should continue this work towards securing those benefits. The bills that are before you would help to make sure that people have the benefits of that expungement when it comes to housing and employment. And Rep. Snyder will share more about what the legislation does.
Good morning, Chairwoman Hope and members of the committee. Thank you for hearing testimony today, and thank you to Representative Grant for spearheading this bill package and including me. House Bills 4948 and 4960 amend landlord-tenant law and Elliott Larson to prohibit landlords and employers from requiring disclosure of previously expunged convictions. The simple concept behind the bills is the following. If you successfully got a conviction expunged and have gotten your clean slate, bad actors should not be able to work around it. You should not be forced or required to acknowledge an expungement because acknowledging an expunged conviction on an application neutralizes the benefits of said expungement. We do not believe that all employers and landlords are determined to seek this information, but we do know that expungement is becoming more and more common every day in Michigan, and the potential for someone to work around it can increase as expungement becomes more commonplace. Instead of waiting for someone to take advantage of this gap in our laws, we are seeking to plug it now and be proactive, preventing this conflict from ever happening. We want to make clear that this legislation only applies to expunged crimes and related information, not criminal history in general. Criminal background checks are critical to the employment and housing application process, and we are not seeking to change this. These bills only seek to protect benefits that come from successfully expunging a conviction, which requires someone to be crime-free for between 3 to 7 years, depending on the conviction. Thank you, and I'll turn it back to Rep. Grant.
In closing, an expungement is something that has to be earned, and we owe it to those individuals to make sure that our laws are airtight so their clean slate can be protected. I'm proud to sponsor these bills alongside Rep. Snyder, and we are happy to take any questions on the legislation. Thank you and the committee for your time.
Thank you. We do have a question from Representative Filler.
Thank you. And Rep. Grant, thanks for calling yesterday and giving me some background because expungement is something I worked on and very proud on. So I just kind of want to know how the bill works. And so I have a couple questions if the chair allows, but I just want to be clear. The bills prohibit a landlord or an employer from asking about an adult's prior convictions that have been expunged too. It's adult and juvenile, is that right?
Yes, so it would include any records that have been sealed or expunged. So if your juvenile record is sealed, it would apply to that, and your adult record, if it has been completely expunged, it would apply to that as well.
But of course, they can still, on a background check, or I'm sorry, on a form, the form can say, you know, were you convicted of a misdemeanor, were you convicted of a felony? That can still be on a form. These bills don't change that.
Right, exactly.
It just can't say, have you ever had a crime expunged? That can't say anything.
Is
on a
there
form.
anything that you were once convicted of that has been expunged? Any language that is pushing someone to answer, is there something that I can't see anymore that is now there? Asking about information that has been sealed or expunged when someone has taken the process and qualified for that would be prohibited.
Okay, and a follow-up with the chair's permission. Thank you. Tell me about the punishment or the civil fine and how that works. I believe it's 250. First time I read it, I thought it was 2,500, and I said I got lots of questions. But tell me how it works with the 250, I guess, in the bill, and maybe I need to read it a little closer. But
Yes, each of these bills are changing different statutes of law, so they apply a little bit differently. For the landlord piece, it would be a $250 fine up to $2,000. So $250 each day until they have corrected their application process.
so someone could file a claim, a civil claim, against that landlord who put on the form or asked about, or verbally asked
Yes.
about an expunged crime.
Yes, and there is still burden of proof in either scenario, whether it's a verbal inquisition or actually on the application paperwork. There's burden of proof for either way. But yes, if it was found true, it would be $250 each day up to $2,000.
Any other questions? Representative Cerniglo?
Sorry, I guess I do have a question. Maybe I wasn't listening closely enough. So if there's a question that says, have you ever been convicted of a misdemeanor? So that's allowed or that's not allowed? That is allowed. So are people, if their crime has been expunged, would they then answer no? Because that wouldn't really be true.
So there is some conversation about the language, but if someone has gone through the expungement process, they understand what it's for. So they would be able to answer that question and say that there are, no, I don't have a criminal history, we know that there are general questions on applications, and they would be able to check no if their information has been expunged. What we're looking to address is that because, and I know that some may feel, $250 is a lot of money, but essentially you would be changing your application process right now to work around the expungement process. And so we take that seriously if someone is doing that. This is specifically someone who is asking, hey, have you had anything expunged? Have you had anything expunged so that I can find a way to not employ you or not house you? That's the core of what we're getting to.
Okay, yeah, I was just thinking about the actual language, and whether or not someone would feel comfortable giving one answer versus
Yes,
the
so
other.
that is a part of their process with expungement, and they are prepared to fill out forms and do things once they have cleared that process. That's not what we're addressing right here. People are equipped to answer those questions on the forms once they've completed the expungement process.
No, actually, that was a really good conversation point. I'm good right now. Thank you.
Thank you. And it looks like you may have some guests testifying as well. I'll go ahead and read in the cards right now, and then we'll have more testimony on these bills. And I should note that I neglected to mention a card that was in support of 4850 Nathan Triplett from the State Bar of Michigan. Liz Balk from the ACLU of Michigan wishes to speak in support of 4948 and 4960. John Cooper from Safe and Just Michigan supports the bills, does not wish to speak. Rachel Richards from the Michigan League for Public Policy supports both bills, does not wish to speak. Noah Smith, representing the Criminal Defense Attorneys of Michigan, supports both bills, does not wish to speak. I'm not sure if I have two cards from John Cooper, but if I do. John Cooper from Safe and Just Michigan supports the bills, does not wish to speak. Tony Gant from Nation Outside supports the bills, does not wish to speak. Aaron Van Langenfeld supports the bills, does not wish to speak. He's representing the Michigan Department of Attorney General. Sean Holohan from Gifford supports 4945 and 4946, we're not on those yet. Those are the domestic violence bills, aren't they? All right, well, I can mess stuff up on my own, Melissa. All right, it looks like we have Ms. Balk and anyone else? Is there another person too? Come on up.
Thanks, Russ.
And make sure to give us your names as you get started.
Good morning, Chair Hope and members of the committee. My name is Liz Balk, and I am with ACLU of Michigan. I'm a policy strategist there, and I'm here this morning to express our support of these two bills. I've already given you written statements, so I'll be brief, and I know we have other folks who wish to speak, so I will make this quick. As you've heard from your colleagues, these bills would provide clear privacy protections to prospective tenants and employees who are looking for work, looking for housing, and for records that have already been properly expunged, and sealed juvenile records. You know, in the case that a landlord or an employer does ask these questions, there are two different bills for two different types of relief, but they essentially involve the same thing. One would be injunctive relief, which means you have to stop asking those questions or including that on your form. Another would be penalty, which we just discussed with Rep. Filler. And then a third would be reasonable attorney fees. So, you know, as more and more Michiganders are eligible to set aside these certain criminal convictions under the clean slate laws, it's important to ensure that landlords and employers do not violate the privacy rights of prospective and current tenants and employees by asking unnecessary and overreaching questions about expunged and juvenile records. So we urge this committee to pass 4948 and 4960 as part of this common sense clean slate kind of cleanup bills and ensure privacy protections for Michiganders. Thank you.
Thank you.
Good morning. My name is Erica Edwards, and I'm here today in support of the HB Bill 4948 and 4960, which help individuals such as myself secure the benefits of having an expungement conviction. In 2012 of October, I was registered as a convicted felon for a CCW charge. I was staying with my brother, who was a drug dealer, who was shot, and I took him to the hospital in his car with his gun. Eventually, I was charged in 2013 with a CCW felony because I had possession of the gun in his car, a gun I never touched before that didn't have my fingerprints on it, but I didn't know the law at that time, and I pled guilty to get it over with. This conviction lasted on my record for 7 years, and it impacted me with housing, it impacted me with employment, and it impacted me with my, at the time, 1-year-old son during those 7 years. I was not able to volunteer at his school because of my conviction record. I would apply for jobs, and I would be denied because of my conviction record. So I just got to a point when I was applying for my government contracts, and they said we have to run a background check. I just wouldn't even go to the second meeting. I was applied after, during that time, I heard a radio announcement for Grand Rapids to Cooley Law School to expunge the conviction. I went there, I applied, and I met someone named Kumar who helped me lead to the path of getting my felony conviction expunged. He helped me acquire that in 2020. In 2021, I applied for housing in Aspen Lakes of Hope, Michigan, and I was denied because they pulled a prior record that had my expungement on it that was completely expunged, and I was denied housing there. Today I have secured, it is working for me. I'm thankful for the expungement, so I thank you very much for that. I am a national sales manager at the Alden Group. I have been there for the past 3 years. I stay in Okemos at Elevation Apartment, and without the benefit of this bill coming through, people like me will be stuck in a place where they can't move forward anymore. My past conviction was expunged. I was given a second chance in life, but I was ultimately denied housing because of a past record that was not supposed to be pulled. It was sealed. It had been removed from my record from the state and federal, but for some reason they got a past report, and I was still denied housing from it.
Thank you. Do we have questions? No questions? Questions? Minority Vice Chair?
All good right now.
All right. Thank you for your testimony. I'm sorry that happened to you, but I'm glad that things are working out right now.
It is, and today I get to volunteer at my son at Hall Park next year, so,
Oh, that's great.
and school tomorrow. So.
We are briefly going at ease at the call of the chair. The Criminal Justice Committee will return to order. We took testimony on House Bills 4945 and 4946 last week. We do have cards. In support of the bills, not wishing to speak, Rachel Richards from the Michigan League for Public Policy. Supporting the bills, not wishing to speak, Aaron Van Lingenfeld from the Michigan Department of Attorney General. Opposing the bill and wishing to speak, but we're not taking testimony this week on these bills, Tom Lambert from Michigan Open Carry. And opposing the bills, also wishing to speak, Brendan Bodrew from Great Lakes Gun Rights. Supporting the bills is Sean Holohan, State Legislative Director for Giffords. Supporting 4945 and 4946, Mary Pollock from the American Association of University Women of Michigan. I'll take a motion to report HB 4945 with recommendation. Thank you, Rep. Breen. Madam Clerk, would you please call the vote?
Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Green. Aye. Young, Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Pass.
Mueller,
No.
Bazat, Harris, Bagol.
Pass.
Madam Chair, you have 7 yeas, 1 nay, 2 pass. House Bill 4945 is reported with recommendation.
Thank you, Madam Clerk. We have 3 amendments before us for HB 4946. I'll take a motion from Representative Filler to adopt the first amendment for
Sure.
HB 4946.
Could I speak quickly to my First Amendment, Madam Chair?
May.
Thank you. This changes the time period, which currently sits at 8 years, that an individual, sort of a waiting period or time period, to 3 years to match lower level felonies. Because I guess it's my opinion that 8 years is an excessive time, especially when it's for a misdemeanor, when the current is 5 years for a felony. So misdemeanors being not as serious as felonies. So I move my amendment. Thank you.
Thank you. Madam Clerk, would you please call the vote?
To adopt the Rep. Filler number 1 amendment to House Bill 4946. Chair Hope,
No.
Representatives Andrews,
No.
Carter,
No.
Breen,
No.
Young, Arbit,
No.
Devendorf,
No.
Cerniglu,
No.
Filler,
Yes.
Mueller,
Yes.
Bazat, Harris, Bagol.
Yes.
Madam Chair, you have 3 yeas, 7 nays, 0 pass. The amendment is not adopted.
Thank you. I will take a motion from Representative Filler to adopt the second amendment for HB 4946.
Thanks, Chair, and I'll speak quickly to that amendment with your permission.
Yes.
All right. This changes, amends page 5 in line 12. Instead of person, it inserts within the previous 10 years. And then amends page 5, line 15 after the first resident by inserting of the convicted person's household. And essentially what this does is puts a little limit on prior dating relationships and roommates to 10 years. Sort of guardrails on how long we go back for what is a relevant domestic violence, and wouldn't affect ex-spouses or people with children in common. And I move my amendment. Thank you, Chair.
Thank you, Madam Clerk. Please call the vote.
Chair Hope,
No.
Representatives Andrews,
No.
Carter,
No.
Breen,
No.
Young, Arbit,
No.
Devendorf, Cerniglu,
No.
Filler,
Yes.
Mueller,
Yes.
Bazat, Harris, Bagol.
Yes.
Madam Chair, you have 3 yeas, 7 nays, 0 pass. The amendment is not adopted.
I will take a motion from Representative Andrews to adopt the third amendment for HB 4946, which is a technical amendment, which after probation strikes out or parole. Madam Clerk, would you please call the vote?
Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen, Young, Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Yes.
Mueller,
Yes.
Bazat, Harris, Bagol.
Yes.
Madam Chair, you have 10 yeas, 0 nays, and 0 pass. The amendment is adopted.
Thank you. Representative Carter moves to report HB 4946 with recommendation as amended as a new substitute. Madam Clerk, would you please call the vote?
Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen, Young, Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Pass.
Mueller,
No.
Bazat, Harris, Bagol.
Pass.
Madam Chair, you have 7 yeas, 1 nay, 2 pass. House Bill 4946 is reported with recommendation as amended as a new sub.
Thank you. Turning now to House Bill 4718. We took testimony on this bill also last week. We do have a few cards to read in. Rachel Richards from the Michigan League for Public Policy supports the bills, does not wish to speak. The bill, sorry. Heath Lowry from the Michigan Coalition to End Domestic and Sexual Violence supports the bill, does not wish to speak. Mary Pollock, representing the American Association of University Women of Michigan, supports the bill, does not wish to speak. Representative Devendorf moves to report HB 4718 with recommendation.
Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen, Young, Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Pass.
Mueller,
Pass.
Bazat, Harris, Bagol.
Pass.
Madam Chair, you have 7 yeas, 0 nays, 3 pass. House Bill 4718 is reported with recommendation.
Thank you. Representative Carter moves to excuse absent members. There being no objection, the motion prevails by unanimous consent. There being no further business before the committee will stand adjourned.